For my presentation, I will be talking about the Sixth Amendment. The first 10 amendments were introduced by James Madison to the United States as a series of legislative articles and came into effect as constitutional amendments, following the process of ratification by 3/4 of the states on December 15, 1791. In simple terms, the Sixth Amendment guarantees a cluster of rights designed to make criminal prosecutions more accurate, fair, and legitimate. Those rights would be the right to speedy trial, which basically means that the defendant is tried for the alleged crimes within a reasonable time after being arrested. In most extreme situations, when a court determines that the delay between arrest and trial was unreasonable and prejudicial to the defendant, the court dismisses the case altogether. The right to a public trial. The purpose of a public trial is to prevent abuse in secret proceedings, which abuse may lead to the oppression of an accused person. The right to an impartial jury. This applies to a jury that hears a case with no prejudice and will give a fair verdict. The right to inform of pending changes, which permits defendants to prepare a defense with the nature and cause of the accusations toward them. The right to confront and to cross-examine adverse witnesses. It provides that a person accused of a crime has the right to confront and witness against them in a criminal action. The right to use the compulsory process of the judiciary to subpoena witnesses who could provide exculpatory testimony or who have other information that is favorable to the defense. And then the right to legal counsel, an effective lawyer that will be an adequate defense for you. I will be talking about two cases that are connected to the Sixth Amendment. The first one is Powell versus Alabama. In Jackson County, Alabama, March 25th, 1931, African-American teenage boys get into a fight with 6 white teenage boys on a freight train that all illegally hitched a ride on. The 6 white boys were then kicked off the train since they were the ones who started the fight. Of course, they didn't like that, so they went to the sheriff in the nearby town of Paint Rock to say they were assaulted. The sheriff got together a mob of people and ordered the train to stop and have every African-American on board arrested. Eventually, they were able to narrow it down to suspects to 9 boys. You have Clarence Norris right here, Charles Weems, Haywood Patterson, Ozzie Powell, Willie Robertson, Eugene Williams, Montgomery, Annie Wright, and Roy Wright, though both Wrights are siblings. Norris is 19, Weems 19, Patterson 18, Powell 16, Robertson 16, William 13, Montgomery 17, Andy 19, and Roy 12. Of these 9 boys, only 4 knew each other before getting arrested together. While the boys were in custody, 2 white women who were also on the train, Victoria Price and Ruby Bates, approached authorities and claimed they had been raped by the boys after the white boys had been kicked off. A doctor examined the girls for signs of rape but did not find any. Word got out about the charges and a big mob formed outside of the jail. Due to the racism of the time and place, the mob automatically thought the boys were guilty. The Alabama Army National Guard had to come to protect the jail from the mob. The 9 boys were later called the Scottsboro Boys since their case was first heard in nearby Scottsboro, Alabama. From the very beginning, the justice system made it so these boys were guilty until proven innocent. Before the trials, they were not allowed to seek legal counsel or even contact their families. The trials were completed in 4 days. The 2 lawyers who defended the boys were not given enough time to prepare for the case and didn't even give closing arguments. The only evidence considered was the testimony of Victoria Price and Ruby Bates. The all-white jury didn't need much time to think about it and claim guilty. And because rape was punishable by death in Alabama, at the time, the 8 oldest boys were sentenced to the electric chair, scheduled to die on July 10, 1931. 12-year-old wasn't because they didn't know whether he should go since he was too young, so it was hold off for him. Lawyer George W. Chamley led a team to open a new investigation to prove the boys' innocence and hold off on the executions. He also got an appeal to the Alabama Supreme Court, arguing the boys were not given a fair trial. Thus came Powell v. Alabama, when the trial violated the Sixth Amendment in terms of the group not providing adequate legal counsel. Given the chance for a retrial, the boys were still guilty, even after Ruby Bates came into one of the trials and claimed that the rape was not true. The jury, no matter if they changed them or not, still believed the boys were guilty of a crime they didn't commit. They kept asking for a retrial, and even though that they got the chance to be in court again, they were back to being guilty because it was just they were black and all the courts were white, so their minds were just set on that. Ozzie Powell, who had suffered from mental illness due to solitary confinement in prison, attacked a guard who had abused him. The guard shot Ozzie in the head. Ozzie survived, but had trouble speaking, hearing, and remembering stuff the rest of his life. I did shorten this up a little bit because this is connected. The Powell v. Alabama is connected to the Scottsboro boys. So if you want to know more information, you could go on YouTube, look up Powell v. Alabama, and go to Mr. Beath's page. That's where I got the information. Now you have Gideon v. Wright. Panama City, Florida, June 3rd, 1961, sometimes between midnight and 8 a.m., someone breaks into the Bay Harbor pool room and steals money from a cash register. One witness reports that they saw Clarence Earl Gideon walk out of the pool room at around 5:30 that morning with his pocket full of money and wine. Police arrested him for breaking and entering and trying to steal, but as it turns out, Gideon does not have any money. Because he couldn't afford a lawyer, he asked a Florida Circuit Court judge to appoint one for him, claiming the Sixth Amendment of the Constitution guarantees everyone a lawyer, but the judge denied his request. Gideon had to represent himself but didn't do so good of a job, so he had found guilty and sent to prison for 5 years. While serving his sentence in Florida State Prison, Gideon began to teach himself law, which made him even more confident that his rights were being violated when the Florida Circuit Court refused to provide a lawyer for him. From his prison cell, he had wrote a letter directly to the Supreme Court. Not only did the Supreme Court actually read his petition, they agreed to actually hear his case. He was allowed a new trial with a suitable lawyer. The new trial took place August 5th, 1963, 5 months after the Supreme Court decision. The jury found Gideon not guilty after just 1 hour of deliberation. Gideon was free. Those are the two popular cases that are connected to the Sixth Amendment. And I really enjoyed learning and getting to talk about it to you guys. Here are my citations, and it's supposed to say the end. But that concludes my presentation. Thank you for listening.